I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we will be jumping into our 23rd compilation video here on the channel, and we will be in 3 different judges' courtrooms for some of these throwback moments from here on the channel and some of the proceedings that we've sat in the past. The first judge's courtroom we're going to be in is the courtroom of Judge Aaliyah Sabree out of the state of Michigan. The second courtroom we're going to be in is Judge Sean Perkins, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Abbey McMahon out of the state of Washington. And once again, these are some classic moments that we've had from the channel, some videos that we've had a lot of commentary on. You guys had a lot to say on these videos. And just for FYI, 2 of these proceedings, the Judge Aaliyah Sabree and the Judge Abbey McMahon, these are clips from longer proceedings. So we will have the links in the description so that you can go and check out the full proceeding. Know that there will be no commentary at the end and there will be chapters added to these videos. And with that being said, guys, let's go ahead and jump into this compilation.
Okay, on page 10, the court held the U.S. Supreme Court under the Supremacy Clause, which is he is bound because, Judge, if you rule against me today, you must hold him in contempt of court and also hold him in treason. The court held the legislative authority of the Union must first make an act of crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense. Certain applying powers must necessarily result to our courts of justice. But jurisdiction of crimes against the state is not amongst those powers, Judge. See Hudson versus Goodwin. 7 U.S. 32 at 33 and 34, 1812. This is still good law, Judge. He's arguing a state statute or a state constitution, which the state received its power from Congress. So how can you buck the system which gave you power to act as a corporate organization? Michigan became a state in 1829. Which Congress gave them their power. The U.S. Supreme Court clearly says that, like they say, people of the state of Michigan versus me. You're saying I committed a crime against the state. The Constitution just clearly says that from the U.S. Supreme Court justices in a unanimous decision in which this court, as well as the prosecution under Article 6, Section 3, the executive department has sworn to uphold, as well as the lawyer's oath in the Michigan Bar Journal. Amongst other things, they're committing felonies, and this court cannot conspire or enter into conspiracy with these individuals to violate my constitutional rights, Judge. And the law is clear. One more thing, if I may. My driver's license. And page 20. You have one? Pardon? You have a driver's license? Yes, ma'am. Oh. But let me, I'm about to go here. And agree that at the onset of these unlawful attacks by the corporations and its criminal agents, that he did reserve his rights under UCC 1-308, MCL 440-1308, UCC 1-103.6, Siege offers driver's license. I reserve my rights on my driver's license, Judge, so the state knows this. I've never entered in because I was compelled to have a driver's license. And what I'm saying is they're committing treason.
First issue, can I see the emails? I just want to make sure that
I give you my phone. I've never gotten anything. I have to show where I sent him the stuff, but I never got that back.
No, oh, let's say I didn't see it.
No.
This is your email address.
It's Carnell, CARNELL, MCCRE@gmail.com, which I wrote it down for him.
C-R-E?
Pardon?
Can you spell the whole thing again?
It's Carnell McQuarrie, MCC. It's my first and last name @gmail.com.
CMCCR
EARY.
Okay.
Also, there's a case I didn't bring with me today where concerning this type of document, he's trying to title this a motion, Judge, so it was a quasi-contract which was recognized by the Michigan Supreme Court.
Between you two as what it is.
Pardon?
You think it's a quasi-contract, he believes it to be a motion. That's
Well, I mean, it's
the
clear.
way it is. That's what it is.
Well, the federal law says that he cannot just see and hear. The Supreme Court said that I'm the legislator of this contract.
Okay.
The litigation.
Yeah, your contract.
Yeah, this is in the Supreme Court. They have to obey the Supreme Court. Object.
What part?
I object, Your Honor.
There are some elements that people like to respond to.
I haven't finished my oration.
I'll give you, it's gonna take a couple seconds. One of those emails, the E is Michigan in there.
That's not my fault. They violate your order. Yes, ma'am.
Okay. Is the other one,
One of them has it spelled correctly, one of them does not.
so you should have received one of them,
Nothing.
and neither one of them came back as bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it.
He didn't send, can we subpoena Google and,
No,
litigate this and
This
show that
is
he
not,
hasn't
this
sent
is not a
anything?
trial, this is not an evidentiary hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address. You can even send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, not, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge.
let's,
Right?
before we get to that, Adrian said something you want to respond before we forget.
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given complete powers to the states, which then allows the states to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may.
Sure.
Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
there are people.
But I
getting locked up
reserve
for-
my
for
rights. This was
murdering
the law.
people As well,
Pardon?
people getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
And
had an
then,
exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court. So I'm demanding that I mean, they're already in default, but still again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights then in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, that way. So, do you have any last?
Well, I would like,
Statements, because I'm getting ready.
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case, personal, subject matter and territorial jurisdiction, state and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it's an email, please tell me if there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Bar.
ain't saying that.
RP numbers are available for you to look up as they are for any general public. Okay. As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both. So I took an oath, uphold the Constitution of the United States, the Constitution of this state to the best of my ability. And with that, I hear cases that were committed, crimes that were allegedly committed in the city of Detroit. That is the venue for this court. I know that you disagree, but I am letting you know that's what I have to follow based off of the oath that I took. And the right to have exams is under Michigan Court Rule 6.110 that governs preliminary exams, as well as MCL 766.1 talks about your statutory right, not constitutional right, your statutory right to have an exam. And under, let's see here, where should I go next? I'm not going to continue citing the rule of law, but under MCL 600.8317, I have the power to hear preliminary examination matters. MCL 766.1 gives me the jurisdiction, and it states in 3 Attorney General 129 Mich. App 128, specifically page 132, which is the 1983 case, and the district court has no authority to grant a motion for change of venue before a preliminary examination is held. The statute granting courts of record authority to change venue in criminal cases is only applicable to circuit courts and felony cases. We are at the district court level. We have not heard any testimony. I don't know anything about this case. So I am denying your request. I will call a motion regarding venue, as well as jurisdiction, or any allegations at this point that the people have been conspiring to commit crimes. I would like to hear the testimony from the allegations, from the information and the complaint. So I would like to set this for an exam date so that we can move forward and actually hear testimony so I can make a decision as to whether or not the probable cause that these crimes even existed. Mr. McCreary, I know you're not happy with my decision. You know the rights, you know your rights and what you can do. You do not agree, but we need to get an exam put on the calendar. And of course, you have a right to an attorney. You have exercised the right to not have one. But I'd like to set a date for an exam and move forward from there. Yes.
May I just place my objections? I mean, you made your ruling, but
And
may
I
I
said I
place,
know you objected.
yes, may I place my, no, I'm saying I have to do it verbally. I mean, per me reviewing past cases from the higher courts, it has to be in the lower court record. I would ask that this court allow an interlocutory appeal to the Michigan, to the Wayne County 3rd Circuit Court under MCR 7.101, 7.102, as well as I would like this case to be removed to the federal court under 28 USC 1441 through 1449, because this court, with all due respect, has committed treason against me and conspiracy with the state. Because under federal law, I had brought a federal question. Once a federal question is presented to this court must rule based on the federal question, which this court has clearly ignored. Okay, I mean, I'm just saying what the court, what the case law says.
You can't just come in here and raise a federal question and be able to shop and go to a different court.
Well, even the state says jurisdictional challenge.
Well,
I brought both case laws.
I understand that you're making a record, but until the exam is held, I can't change it based off of what happened.
Oh, no, I understand, but I'm saying you can make other decisions and rulings of law. May I ask this question?
Is it a question?
Is it okay for the court to ignore U.S. Supreme Court case law, which is in the superior court to this inferior court here, a district court? And I'll, ask that this be removed to the federal court for adjudication, as well as Wayne County.
And I just said,
the remove
until the
statute.
exam is held, I can't.
Well,
I can't change venue.
But no, I'm just saying the jurisdictional challenge, they're bound to respond, Judge. And the case law is clear, and this court is ignoring state and federal case law, which
I
they're
don't believe
supposed
I am
to.
ignoring anything. I've sat here, I have a timer on my phone. I've sat here and listened to you talk
Okay.
for 34 minutes and 54 seconds. So I don't think that I've ignored much of anything.
Well,
The
I'm
average
saying,
judge would not sit here and let you talk this long. There are time limits on motions and requests. So I think I've done a great job of not ignoring. I've heard everything you said. I've read your paperwork and I've addressed it and responded. I just don't agree with it. So I understand your objection. If you don't agree with anything that I have said, I understand that. And I am ready to set an exam date.
well, I'm being compelled. May I have your bar number, Judge? Because it's not up there.
Look it up with my name.
I mean, I thought this was public information.
I gave you the freedom to go to the library, so you do it yourself.
And then
I gave you the
also,
freedom to go to
I need their names. I don't know how to spell their names. I mean, can they write their names down for me? So I can file attorney grievance complaints with the Attorney Grievance Commission, Your
So
Honor?
I'm.
I don't know their first and last names. I need this to petition the
I'd like to
attorney.
set an exam date.
I mean, I'm being compelled to go to an exam.
So we're gonna. set
Violation of
an
federal and
exam
state
date
law.
For June. I'm thinking June 13th. I don't know if that works. You go first.
Yeah, that's my birthday. Y'all trying to bring me on my birthday.
Your Honor, I'm not in court that day.
Okay, let's not do that day.
Well,
But is that, just previously, I'm not gonna have to do it first.
okay. I mean, I would like their names. That's all I need. So I can go
I
to
would
the
like
federal
to set an
courts.
exam date.
Things of that name. I mean, I'm being compelled. Judge, right now, you have me here under threat, duress and coercion. I can't even work to support myself.
I allowed you to work.
Well, it's across the street, but that's not every day.
That's what you asked.
And,
for.
and people have been
That's what
contacting
you
me.
asked for.
Okay, no, I understand, but people have been contacting me about a job. I've been in the community. I've been home. from
You want to
prison.
address bond? We can address
Sure.
bond after we get an exam date.
Well, I'm just gonna have a tether on. I'm not gonna run
I
out
don't
the
know
door and let
what
them
you're
get me.
going to do, but I want to set an exam date.
I mean, I'm compelled. That's your call. Your call.
Okay, I need to set an exam date still, whether you feel compelled or not. June 15th.
I'm here that day, Your Honor.
Okay,
I'm here as a standby, Your Honor.
okay. Mr. McCreary, can you do 9:30?
I mean, I'll be here.
Yes,
Anytime you want me here, I'll be here. But I would also need, they're saying about the email, why can't they just print it off like they used to back in the day? It's a violation of MCR 6.201, like when I asked for their bond numbers and
Just
other
request it,
things.
ask, you just ask.
That's pertinent. I did, and they
Just
told me they
ask.
weren't gonna do
Your
it the
Honor,
last time we were here.
Mr. McCurry, let the record reflect that I have 15 pages of discovery that I am now handing to the defendant. This is all that we have.
Is it complete? Because I would like an in-camera review of your file as well, on the
It
MCR
is.
6.201. Can I review his file on the MCR 6.201? So, because they have a history of holding stuff back from, which is all,
That's a strong
document.
allegation for people you don't even know.
what I'm saying, in her office, Kim Worthy's office, they work in behalf, they're her supporters. Notice the agent is notice the principal, notice the principal is notice the agent. Under
Put
state
on
and
the
federal
record
law.
first that Mr. Sawaki has handed over 15 pages of a hard copy of discovery.
Is there medical reports in here as well? Because he said someone was shot and beat up, and where's the ammunition? I need pictures of the guns and all the stuff. These fictitious guns and everything that they're talking about they have.
You think that they're going to hand you the guns?
No. What I'm saying is they say ammunition, guns, and other charges. Where's the evidence?
That's
This
what
is
he's
just.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Himmer Hicks Jr. Case number SP 1442547, counts 1, 2, and 3. SP 1442761. Appearance for the record, please. And strike, now wait a minute, SP 1500871. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer that's in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks. You're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay, so take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so Now, I'm gonna give you two
As a matter of
options.
fact, hold on, give me a minute, give me a minute. You
Go
even
ahead.
went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
You don't even have a
I
license
thought
to
about that.
practice law.
Listen, this
You
whole,
don't have a license to practice law. Come on, the jig is up. The jig is up.
all right, so now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now, I'm gonna give you two options. The first option is you can either take the deal that's in the file, or we can, okay, don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now, I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court, okay? All right. So the other option is we set a jury trial. And we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on, and I'm going to put you out, or at least mute yourself. Very well, officers. Be safe out there. Have a very good day. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
Record, Your Honor. Chiku Mason, City of Detroit, 434.
Yeah, something's wrong with your volume, Ms. Mason.
Oh, I'm sorry, Your Honor. It might be my mic is down. For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP 1442547 counts 1, 2, and 3, SP 1442761, and SP 5008721. I'm only dealing with those matters, and the officers are not here, so we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay, so let's get that straight. This robe has nothing to do with me as a man. But all right, I'm gonna dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that
No, she did. It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't until later. But regardless, you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald, have you gotten that yet?
I just
Perfect. Have
So,
you
Mr.
have you had a chance to read over that, Miss?
So obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to you, ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning.
That's not my question, Mr. Schuster.
Well, I'm answering your question. I would like to
I don't want a
speak.
narrative. Yes or no?
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I
well,
don't know
your
what paper you're
signature is
showing me.
here on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just
Schuster-
very hard to read because it's blurry
Okay.
from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
this isn't
nonetheless,
so.
I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion Finding that this court, again, does have subject matter jurisdiction in this case will proceed. So those motions are denied. I am also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. You know, in the beginning, you had the correct address. It's no longer the correct address.
then it's
And
not the
so,
correct address. If it's no longer correct, then it's not correct. You've given a
well,
Kennewick
as of recent, as of literally not that long ago.
So when
So,
did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
I mean, it's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated. I can
And
tell
this
the
is a
court
court of record, correct?
is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, you know, everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family. And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that you're saying that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty and, a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal matter?
I'm saying that there are multiple layers of jurisdiction that involve travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you represent,
Most definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well, as I've stated, this case should be moved to the proper courtroom, which it's not.
In the proper courtroom, and that's not happening. And Mr.
If it's not transferred, I do, it should be dismissed.
I'm not entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
Oh no, you have my email. You got the information on the motions there. So you have the email listed above. I don't really know how to use Zoom like that, and so sending anything over through chat like this is just it's difficult. So email would be the best way if you want to get that to me faster. But of course, you have an address now that I'd be able to get the mail that you're saying you've sent already, but no worries. So
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that chat.
We didn't have a back and forth.
We did.
Chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So if you'd like
as I stated, you can email it so that I can properly see it, because that's the best way for me to do it quickly, because I don't really know how to use this chat function in Zoom.
Ms. McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal. But I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
So we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Then spell out your email for Ms. McDonald.
Do you know how to spell my last name, Ms. McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name .jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Ms. McDonald?
Yes, I am.
Okay. SCH.
Okay.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. But SCH, USTER.
Okay.
You got that?
Yes.
Oh, okay. So my last name, John, JON.
Okay.
You got that?
Yes.
Oh, okay. At iCloud.com. And, it's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too. So that's just kind of ironic that you would mention that.
Yeah. Well, as I said at the beginning of court, everything's being broadcast on YouTube, but
I know.
We
but
need
nonetheless,
to respond to the fact that you have changed your address repeatedly.
Nonetheless, that's just
emailing you.
Ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well. So, or
No,
information in the mail?
it's not coming in the mail. It's coming via email right now. You have the
Oh,
opportunity to
I'm
review
talking
it
about
right now.
like the other information she was.
No, that's already been sent in the mail. You need to go to wherever those addresses were to get your discovery.
Mm.
The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record when the judge denied subject matter jurisdiction?
When you were in court on the record.
On that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you have provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
So you're not going to send it to the proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right.
And so my email, I'm using the same.
Camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
I'm not threatening you. Say one more word and that's 30 days. 30 days.